So this is the second part of our notes in Zultri on the parties. So so class suit, the requisite for class suit would be the subject matter must be of common or general interest to many persons. Next would be the person are so numerous that it is impracticable to join all as parties. The parties actually before the court are sufficiently numerous and representatives as to fully protect the interests of all concerned and the representatives to sue or defend for the benefit of all. So normally class suits are done through if the case is culpa or negligence or sometimes we call it torts, diba? So the subject matter for common or general interest, we define that as common or general interest is the most important requisite for class suits. Often, class suits are not considered class suits because each plaintiff has a separate and distinct injury or interest. Note, ask yourself if all of those concerned can protect their interests in the same manner or in a different manner. If they have to protect their interests in a different manner, then their representatives cannot fully protect the rights of those who are not impleaded. Thus, all of those concerned must be impleaded in the suit. What then is the remedy? They cannot file a class suit. Instead, they can file one action and there will be a joinder of causes of action and parties. The big difference is in joinder of causes of action, the parties of all of them must be impleaded. Examples of existence of common or general interest. One, the cancellation of a timber license to protect the environment for all Filipino citizens, including the generations yet unborn. This is Oposa versus Factoran, and the resident of the subdivision who were deprived of the use of La Paz Road by Phil Estate Land on Wana Complex versus Phil Estate Land. Example for non-existence of common or general interest, heirs of the victim of a plane crash or a shipwreck. Residents exposed to chemicals from a cooking gas plant. Residents who are opposed or in favor of the recovery of patron saint statue. A corporation suing in behalf of the stockholder for the recovery of certain parcels of land. Corporation is merely the agent of the stockholder. Each of the stockholders is a separate and distinct interest. The Association of Sugar Planters filed the filed the claim for damages in behalf of each sugar planter because a libelous article ruined their personal reputation. Next, a libelous article directed at a group of persons cannot be a subject of class suit. It is not a case where one or more may sue for the benefit of all, or where the representation of class interests affected by the judgment or decree is indispensable to make each of the member of the class an actual party. Each of the plaintiffs here are has a separate and distinct reputation in the community. They do not have the common or general interest in the subject matter of the controversy. Newsweek Incorporated versus Intermediate Appellate Court, May 30, 1986. Uh, is derivative suit a class suit? No. A derivative suit is not a class suit. A derivative suit must be differentiated from individual and representative or class suits. Thus, suits by stockholders or members of the corporation based on wrongful or fraudulent acts of directors or other person may be classified into individual suits, class suits, and derivative suits where a stockholder or member is denied the right of inspection. His suit would be individual because the wrong is done to him personally and not to the other stockholder or the corporation. Where the wrong is done to a group of stockholders, as where the preferred stockholders' rights are violated. A class or representative suit will be proper for the protection of all stockholders belonging to the same group, but where the acts complained of constitute a wrong in the corporation itself, the cause of action belongs to the corporation, not the individual stockholder or member. Although in most every case of wrong in the corporation, each stockholder is necessarily affected because the value of his interest therein would be impaired. This fact of itself is not sufficient to give him an individual cause of action, since the corporation is a person distinct and separate from him and can and should itself sue the wrongdoer. Otherwise, not only would the theory of separate entity be violated, but there would be multiplicity of suits as well as a violation of the priority rights of creditors. Furthermore, there is the difficulty of determining the amount of damages that should be paid to each individual stockholder. However, in cases of mismanagement where the wrongful acts are committed by the directors or trustees themselves, a stockholder or a member may find that he has to redress because the former are vested by law with the right to decide whether or not the corporation should sue. They will never be willing to sue themselves. The corporation would thus be helpless to seek remedy. Because of the frequent occurrence of such situation, the common law gradually recognized the right of a stockholder to sue in behalf of a corporation in what eventually became known as the derivative suit. It has been proven to be an effective remedy of the minority against the abuses of management. Thus, an individual stockholder is permitted to institute a derivative suit on behalf of the corporation wherein he holds stock in order to protect, where am I? Is permitted to institute a derivative suit on behalf of the corporation wherein he holds stock in order to protect or vindicate the corporate rights. Whenever officials of the corporation refuse to sue or are the ones to be sued or hold the control of the corporation. In such actions, the suing stock the suing stockholder is regarded as the dominant party with the corporation as the party in interest. Next, differentiate class suit and representative suit. A class suit, the plaintiffs themselves are real parties in interest and they also act on behalf of the other real parties in interest. Representative suit, they act on behalf of the real party in interest. They themselves are not real parties in interest, representatives only. 6, differentiate class suit and joinder of parties. A class suit is a form of joinder. However, a class suit is stricter because it requires the plaintiffs to have a common and general interest over the subject matter. Meanwhile, the joinder will still be allowed despite the parties having separate interests if the right of the relief arose from the same transaction and the parties have common question of law or fact between them. An example is the heirs of the victims of shipwreck. 9. Suits against entities without juridical personality. This is the item that we have mentioned earlier on the in the previous video. When two or more persons not organized as an entity with juridical personality enter into a transaction, they may be sued under the name of which they are generally and commonly known. This usually applies to corporation by estoppel and partnership by estoppel. This is permissive in nature since Section 15 used the word may. So an example for this would be Mr. A and Mr. B bought raw materials under the corporate name ABC Corporation from Mr. C. However, upon checking with the SEC, it was revealed that ABC Corp did not exist. Mr. A and Mr. B did not pay the purchase price upon demand. How can Mr. C file an action against Mr. A and Mr. B? Mr. C may sue them under the corporate name ABC Corporation, the name which they generally and commonly known. Next, transfer of interest. In case of transfer of interest, the action may be continued or by or against the original party unless the court upon motion directs the person to whom the interest is transferred to be submitted in the action or joined in the original party. So the court this is a court discretion. The above provision gives the trial court discretion to allow or disallow the substitution or joinder by the transferee. Discretion is permitted because in general the transferee's interest is deemed by law as adequately represented and protected by the participation of his transferor. In the case, there may be no need for the transferee pendente lite to be substituted or may be joined in the case because in legal contemplation he is not really denied protection as his interest is one and the same as his transferor who are already parties in the case. Santiago Land Development Corporation versus Court of Appeals. Who files the motion? The transferee, a stranger in the action, may file the motion for substitution or joinder. So, heirs of Medrano versus De Vera in 2010. So, example, Mr. A is the creditor of Mr. B. Later, Mr. B failed to pay upon demand. Thus, Mr. A filed an action for collection of some money against Mr. B. During the pendency of the proceeding, Mr. A assigned his credit to Mr. C. Mr. B is now contending that the action be dismissed since Mr. A ceased to have any interest over the credit. Should the action be dismissed? No. The action should not be dismissed. Under the rules, in case of a transfer of interest, the action may be continued or against continued by or against the original party unless the court upon motion directs the person to whom the interest is transferred to be substituted in the action or joined in the original party. Hence, the action should not be dismissed because despite the assignment of interest to Mr. C, the action for collection of sum of money will still be continued by Mr. A, the original party, against Mr. B, unless the court upon motion directs Mr. A to be substituted by Mr. C, or directs Mr. C to be joined with Mr. A. 11. Effect of death of party litigant. It extinguishes the attorney-client relationship. The attorney of the deceased client must inform the court of the death of the client. Failure to do so would result in disciplinary action against the attorney. This section applies to civil and criminal cases. What if the attorney failed to inform the court? Then the case will proceed. Because the court cannot be expected to assume the death of the party without the counsel's proper manifestation. Tuanyo versus People in 2016. Further, failure of the counsel to inform the court of the death of his client does not deprive the court of jurisdiction. The decision of the court is binding upon the successor in interest of the deceased. What if he informed the court? The hearing will be suspended until the heir, executor, or administrator of the estate of the deceased client is able to substitute him in the action. This is in compliance with due process. If the proceeding continued despite being informed of the death of the client, the proceedings will be considered null and void for being violative of the right to due process. 12. Death of a party litigant, action of the court. First, the court will check if the claim has been extinguished due to the death of the party litigant. If it is deemed extinguished, then the case will be dismissed. Legal separation case. If it is not extinguished, then the following will take place. The court shall order the legal representative of the deceased, named by the counsel, to appear and be substituted within 30 days from the notice. Section 16, Rule 3. The heirs of the deceased may be allowed to be substituted without requiring the appointment of an executor or an administrator. Formal substitution is not necessary. What's the basis? Article 777 of the Civil Code provides that the rights of the succession are transmitted from the moment of the death of the descendant. Now, if the council did not name a substitute or representative, or the one named fails to appear within the specified period, the court may order the opposing party to procure the appointment of an executor or an administrator for the estate of the deceased within the specified time. There is no need for summons to be served to the heirs who will substitute for the complaint to be amended. Jurisdiction over the person of the heirs, the executor, and the administrator is acquired by the service of the order of substitution. 13. Actions for recovery of money arising from contractual obligations. This applies to quasi-contract and those obligations arising from law. It does not apply to quasi-delicts or delicts. Why? Because Section 20 states express or implied. Recovery of money arising from contract is not extinguished by the death of the party litigant. Hence, if the defendant dies before the entry of final judgment, the court shall not dismiss the suit. This case shall be allowed to continue until entry of final judgment. Note, this presupposes that the complaint for the recovery of money arising from contract was already filed. If it was not filed at the time of the death of the party litigant, Section 20, Rule 3 will not apply. On the other hand, if the defendant dies after the entry of the final judgment, the case would obviously not be dismissed, since the case has been disposed of. So how can we correlate Section 16 of death of party litigant on Section 20? For an action for recovery of money arising from contractual obligations, the court will not dismiss the action of the defend if the defendant dies. Instead, the action shall be allowed to continue until the entry of final judgment. However, before the action will be allowed to continue, the counsel of the party who died must inform the court, one, the fact of his death, and two, the person who will substitute the party litigant in the action. Once the steps in Section 16 were complied with, then the action will now be allowed to continue. Section 20, Rule 3. So, as stated, the case shall be allowed to continue until entry of final judgment. What happens if the plaintiff prevails in the action for recovery of money arising from the contractual obligation? The trial court cannot issue an order of execution. Instead, if the plaintiff obtains a favorable judgment, said judgment shall be enforced following the rules of prosecuting claims against the estate of the deceased. In other words, the motion for issuance of writ of execution will not lie. Instead, the plaintiff must submit his claim in for the action of the settlement of estate of the deceased litigant. So this is the last topic for section Rule 3. Distinguish Section 20, Rule 3, Section 1, Rule 86, and Section 7, Rule 39. Section 20, Rule 3, this applies in actions for recovery of money arising from contractual obligations and the defendant dies before the entry of final judgment. This only applies to the death of the defendant. In Section 1, Rule 86, this applies to all money claims against the descendant. Section 20, Rule 3, and 86 work hand in hand. This only applies to the death of the defendant. Section 7, Rule 39, this applies to special circumstances. If these circumstances do not apply to the factual circumstances in the bar question, we go to Section 20. Rule 3, Section 1, Rule 86. This applies to the death of the defendant or the plaintiff. So, what is Section 1, Rule 86? Immediately after granting letters of testamentary or the administration, the court shall issue the notice requiring all persons having money claims against the descendant to file them in the office of the clerk of court. So, what is Section 7? Rule 39. In the case of death of a party, execution may issue or be enforced in the following manner. In case of death of the judgment, obligee, upon the application of his executor or administrator or successor in interest. In case of death of the judgment, obligor, against the executor or the administrator in interest. If the judgment be for the recovery of real or personal property or enforcement of lien thereon, in case of death of the judgment obligor after execution is actually levied upon and any of the party, the same may be sold for the satisfaction of the judgment obligation, and the officer may take the sale shall account to the corresponding executor or administrator for any surplus in his hands. Example, Mr. A filed an action for collection of sum of money against Mr. B. While the case is pending, Mr. B died. What provision will apply? Section 20, Rule 3. Thus, the action will not be dismissed and shall continue. If the plaintiff prevails, his money claim will be submitted in the estate settlement proceedings under Rule 86. Mr. A filed an action for collection of sum of money against Mr. B. Mr. A prevailed. During the execution stage, Mr. B died. what provision will apply? Rule 86. Thus, his money claim will be submitted in the estate settlement proceedings. Mr. B filed an action for collection of sum of money against Mr. B. Mr. A prevailed. During the execution stage, the sheriff was able to levy the motor vehicle of Mr. B because the motor vehicle was sold in a public auction. Mr. B died. What provision will apply? Section 7, paragraph 3, rule 39. Mr. B died after the sheriff levied his motor vehicle. This vehicle may be sold to satisfy the judgment in favor of Mr. A. Mr. A filed an action for the conveyance for real property against Mr. B. Mr. A prevailed during the execution stage. Mr. B died. What provision will apply? Section 7, paragraph 2, rule 39. Since the judgment is for recovery of property, the execution will be enforced against the administrator of Mr. B's estate. The plaintiff will be able to recover the property without resort to Rule 86. Mr. A filed an action for collection of sum of money against Mr. B. Mr. A prevailed. During the execution stage, Mr. A died. What provision will apply? Section 7, paragraph 1, Rule 39. Thus, the execution may be forced upon the application of the administrator of the estate of the plaintiff. Okay. So that will end our discussion on Rule 3 on parties of civil action.